This is Central Judicial Processing Court. My name is Judge Louis Belasco. You are here because you have been charged with an indictable or a disorderly persons offense. This opening statement is designed to inform you of your rights and the procedure for today. Please listen carefully. If you do not understand what I say or are confused, please let a member of the court staff know at the end of this video. Please also be aware that the court will ask you some questions following up on some of the items I will discuss shortly. I will begin with a reading of your rights. You have the right to remain silent. Any statement you make may be used against you. You are being represented by the public defender for this proceeding only, though you may qualify for continued representation by the public defender if you cannot afford a private attorney. Please be aware that the public defender representing you today may not be your attorney after your case proceeds to the court that will ultimately hear your matter. If you are not a United States citizen, and if you plead guilty to or are convicted of certain offenses, including some motor vehicle offenses, it may result in your being deported from the United States, or it may prevent you from being readmitted to the United States if you leave voluntarily, or it may prevent you from ever becoming a naturalized American citizen. You have a right to seek advice from an attorney about the effect a guilty plea will have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless the prosecutor has filed a pretrial detention motion or you have outstanding detainers that cannot be resolved today. If the state has filed a motion for pretrial detention, then your case will be heard at a later date to determine whether you may be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offense. You will have the right to an attorney, or if you cannot afford an attorney, one may be appointed to you. You will have the right to testify, to present witnesses, to cross-examine witnesses who appear at the hearing, and to present information by proffer or otherwise. Testimony given during the hearing shall not be admissible against you on the issue of whether you are guilty, but your testimony may be admissible in proceedings related to pretrial release, violation of conditions of release, perjury, or for purposes of impeachment. Under the court rules, the state can request a 3-day postponement of the detention hearing. You may request a 5-day postponement of that hearing. While awaiting the hearing, your commitment to the county jail will be continued. If the state withdraws its motion before the hearing, you will be brought back to the court and released on your own recognizance or with conditions of release. However, if the prosecutor has not filed a motion for pretrial detention and you do not have any outstanding detainers, you will be released on your own recognizance or with conditions of release. As a condition of release, you must provide a valid mailing address at which you receive and regularly check mail. You must notify the court handling your case of any change of address. If you fail to notify the court of your change of address and miss a court appearance as a result, a bench warrant may issue for your arrest. Please provide court staff with your mailing address, cell phone number or home phone number, email address, and the best way to reach you in the event that court staff must notify you of a change to your scheduled event. In addition, the court may assign other conditions of release. You must strictly adhere to those conditions. Failure to do so may result in a bench warrant being issued for your arrest or for the revocation of your release. If you are charged with an indictable offense, you have the right to have a hearing as to probable cause and the right to indictment by the grand jury and trial by jury. You may also choose to waive an indictment or trial by jury. If you choose to waive a trial by jury, you will be tried by the court. In that instance, a judge will determine whether you are guilty or not guilty. You may be eligible for the pretrial intervention program. You may also be eligible for the drug court program. In order to be considered for these programs, you must submit an application. Staff in the courtroom will direct you to the relevant materials for making these applications. A special note for military veterans. A program called the Veterans Assistance Project exists to provide veterans with referrals to community-based resources for services relating to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible mentoring by another veteran. Our court staff can provide you with a brochure describing the program and an application. Staff can also help you with completing the application.